This is a story that it's hard to believe, but these are the allegations. A teenage father shoots and kills his newborn daughter in the woods. 2 bullets to the head. He was back in court today. Court TV anchor Michael Ayala has the story.
I will call State of Wisconsin versus Logan T. Quickenberg Anderson.
16-year-old Logan Quickenberg Anderson is charged as an adult with first-degree intentional murder and hiding a corpse in the shooting death of his own newborn daughter.
Mr. Quickenberg Anderson appears via Zoom from the Juvenile Detention Center where he is incarcerated.
Prosecutors say on January 5th, Quickenberg Anderson's 14-year-old girlfriend gave birth to their child in a bathtub in her Albany, Wisconsin home, naming her Harper. In his initial statement to police, the teenager says he and his girlfriend decided they could not have the child in their life, and they agreed that he would get rid of the infant by simply dropping it somewhere. Quickenberg Anderson says he then placed the baby in a backpack and left. He first told police he gave someone $60 to take the baby to an adoption agency. When interviewed a second time, he admitted leaving baby Harper in the woods. Police would later find the newborn with 2 bullet wounds to the head. Baby Harper's mother is listed as a witness and has not been charged with any crime.
You filed a waiver saying that you are waiving that right to appear, for example, at our preliminary hearing next Friday. Do you understand that?
Yes, sir, Your Honor.
In Wisconsin, defendants 15 and older charged with first-degree murder are automatically treated as adults. Quickenberg Anderson's defense will now focus their efforts on trying to convince the judge to remove the case to juvenile court, where the punishment and treatment options are much more favorable.
If they do go to juvenile court, the ceiling, basically the maximum amount of incarceration or penalty that they could receive, is so much less than what he's facing right now.
But getting to juvenile court will not be easy.
I would focus primarily on a psychological defense and talking about brain development and talking about how a person of his age couldn't fully appreciate the seriousness of what he was doing. And I think that is really focusing on him as opposed to the crime is going to be the only way that they have a chance of getting this.
If convicted as an adult, Quickenberg Anderson could spend the rest of his life in prison.
All right, let's bring in Court TV anchor Michael Ayala. Michael, all right, let's break down today's hearing. What was it all about?
All right, well, Vinny, we're still very early in the case. We have yet to even have a probable cause hearing that is set to happen next Friday, February 12th. But today the judge heard 2 motions, both filed by the defense. One to close the case to the public and the other to compel early discovery prior to that probable cause hearing. Now, on the first issue, the defense was concerned that the Zoom hearings would hold more potential to poison the potential jury pool. The prosecution simply argued that there is a strong presumption for open courts in Wisconsin. So let's listen to some of the arguments.
I urge the court to grant the defense motion because of Zoom, frankly. There are the case law is replete with examples of the courts saying, well, I'll exclude all minors from the courtroom or so forth, but the court has no control over who's viewing a court hearing on YouTube. And furthermore, the defendant has a due process right to a fair trial if he's not reverse waived, and I think that that will be compromised by the court publicly hearing his reverse waiver hearing. I think the jury pool will be polluted, if you will, by evidence.
There certainly will be evidence that wouldn't come in at a trial because we'll be dealing with issues that aren't at factor in trial, including, what the defendant's treatment needs might be or things like that. Those aren't even really something that we would get into at a trial. But they haven't indicated that there's anything in particular about that would negatively impact the case beyond just saying, well, the court will hear about the seriousness of the offense and the court's opinion on the seriousness of the offense. The jury already knows about the seriousness of the offense. The jury already knows about what's alleged here. They already know, the public is aware that he is charged with first-degree intentional homicide, shooting a baby in the head.
The genie's already out of the bottle on that matter. There is certainly public awareness of this case. It can cause an issue in selecting a jury. When we go to select a jury here in Greene County, if they have been biased or prejudiced by anything that they have viewed, although that is a potential issue, I don't think it is an issue that is any greater than a lot of cases that get publicity for whatever reason, that they're perceived as being some person of public interest involved or simply because of the nature of the case. Does that justify changing our normal protocol and normally keeping these matters closed? And I think under these circumstances, the answer is no.
All right, Vinny, a second motion involved the defense requesting early discovery, as I mentioned. Now, the next step in this case is a probable cause hearing, where the prosecution presents evidence to show they have probable cause to go forward with the case. Now, normally, they don't have to turn over any information at this point because the burden is wholly on them. But because this is a 16-year-old, there will also be a reverse waiver hearing. You heard that a couple of times there. That's where the defense will try to argue that the case actually belongs in juvenile court. So the defense argued they need more information to properly conduct that hearing. Well, the prosecution countered that there is no statute allowing this and that the proceeding is not meant to be treated like a full-blown trial. Once again, let's listen to the arguments and then the judge's decision.
Initially, I asked for everything because I don't know the extent of what exists in the state's file. I would say minimally having the police reports would be appropriate. So just disclosing that information to the defense doesn't change the hearing in any way. I think the concerns that are cited about having these hearings turn into mini trials, I think by providing that information to the defense, it actually would have the opposite effects because we are then able to streamline our arguments and focus on the facts that are of consequence to the court rather than attempting to eliminate possible defenses through cross-examination.
They haven't argued how this would go to a affirmative defense at the preliminary hearing stage. They haven't argued how this would go to any of the other factors in the reverse waiver stage. Now they're arguing that they just want the police reports and the defendant's statements. The defendant was present for all of the statements that he made. He knows who he made them to. He knows what he said. They would be able to investigate that. They would be able to question about that. It's a hearing. They present their evidence. The state presents its evidence. They can attack our evidence. We can attack their evidence. That's what the hearing is for. And there doesn't seem to be any basis in law for either side to obtain discovery in advance of it. And that is frankly what's understood to happen. If either side would have discovery in advance, it would expand the scope of the hearing.
Just to address the issue of statements, I think anybody who's seen the recorded interview of Brendan Dassey in Making a Murder knows that a recorded statement of a juvenile, regardless of the actual language of the statement, there very well could be things that affect the voluntariness of that statement that may be relevant to a court's determination regarding waivers.
In acknowledging that burden switches over on the waiver hearing to the defendant to show these elements there. There isn't a rule or a case that compels me to do this, nor even frankly suggests that it is appropriate under these circumstances. For those reasons, then, I'm going to deny that motion for discovery prior to the waiver hearing.
All right, so 2 losses for the defense there, Vinny, but it wasn't all bad news. The judge did ultimately rule in favor of the defense on an important issue. Normally, the reverse waiver hearing happens on the same day as the probable cause hearing, but in this case, the judge granted the defense more time to prepare. The defense had argued that because of COVID, they needed more time to get a psychological evaluation done. The prosecution didn't object, and the judge was sympathetic.
All right, so is there realistically any way this ends up going back to juvenile court?
You know, Vinny, I don't think so. It really is a long shot. At the reverse waiver hearing, the burden is on the defendant to prove three things by a preponderance of the evidence. One, that the juvenile could not receive adequate treatment in the adult criminal justice system. Two, transferring jurisdiction would not diminish the seriousness of the crime, and that's where there's going to be a big problem. And three, retaining jurisdiction is not necessary to deter juveniles from committing the same violation. Now, unless the defense uncovers some serious mental issues in the mental evaluation, this is going to be a very, very difficult task and highly unlikely.
All right, this is one we'll continue to track. Michael Ayala, thank you so much.
You're welcome.